Hi, Kim Malek from Malek and Malek. Today, I'm going to talk about carpal tunnel syndrome. And as with a lot of these videos, a lot of times they're prompted by either a claim of a client that I have going on, or a potential client that's called, or a claim that's been filed to court. So carpal tunnel syndrome is a unique condition. It's a unique injury. It comes with its challenges. It's certainly not the easiest type of work injury to get allowed. You can get it allowed, but there are challenges um, that come with carpal tunnel syndrome. Um, so the easy case is you have carpal tunnel syndrome that is developed via direct trauma to the affected arm. So you have a cut in the arm, like a laceration to the arm. Something falls on the arm that causes the problem. Something like that, some kind of direct trauma to the arm that leads to carpal tunnel syndrome. And then another way that this condition develop, and where it's, when I say easier case, it's none of these. There's really no workers' comp claim that's a slam dunk, and but it's easier to get allowed through the workers' comp system. Is it develops as a flow-through condition. So let's say you had surgery in your arm for whatever reason, and then you subsequently develop carpal tunnel syndrome. That would be another way to get it added to your claim. So that's easier. So those are the easy cases, carpal tunnel syndrome. So the hard case would be pursuing carpal tunnel syndrome via what's the theory of occupational diseases. So I've talked about occupational diseases before. There's scheduled occupational diseases. So when I say there's a code section where they talk about occupational diseases associated with working, like around chemicals and metallurgical type situations, you could be exposed to things and you develop what's called like silicosis or asbestosis, where you're exposed to asbestos. And you develop these lung conditions, and these like silicosis can have a number of conditions that could arise from the silicosis itself. But basically you're exposed to something. So those are scheduled occupational diseases. So there's also occupational diseases in the Ohio Virus Code, which defined in 412301F, and it's a disease contracted in the course of employment, which by its cause and the characteristics of its manifestation or the condition of employment results in a hazard which distinguishes the employment and character from employment generally, and the employment creates a risk of contracting the disease in greater degree and in a different manner from the public in general. So, and I talked about this in the context of the COVID-19 cases, but this is applicable to carpal tunnel syndrome situation as well. So basically, you're doing something as part of your job that's kind of unique to your job, and the public doesn't really do this type of thing in their daily life. And so the risk of developing this is higher than what the public exposes. And in a degree, it's more likely it's a much greater degree that you're going to develop this type of condition doing this type of thing in whatever job you're doing, rather than the public at home. So so with these kind of, so there's complicating factors that go into this, depending on what kind of carpal tunnel syndrome you develop. But first we might look at what kind of jobs does the industrial commission or at work activities, do they generally, that the pattern that I've seen where they have accepted claims at the IC is there's different fact patterns that if you see this fact pattern, you're like, okay, that's good, or that's not going to be good. So fact patterns, if you have carpal tunnel syndrome, would be a lot of times the IC likes to see that somebody, and when I say IC, I mean industrial commission, is they like to see some type of machine being used. So you're operating some machine, and it's not like a one-off thing, like once a week. It's daily use, it's hourly use, you're constantly using this machine, whether it's a pneumatic drill or a metal polisher, something that's kind of has a vibratory effect on the affected arm, and you know, and it's just constant. You're constantly, that's day in and day out, you're using this machine. Another situation, fact pattern is, you know, your hand or arm is in a weird position on a daily basis. You're doing some type of motion, you're installing wiring in a car or whatever, and it's basically doing the same wiring motion over and over and over, and that's all you do is put the wire in the car, or you're doing something on a machine and you're constantly doing the same hand motions, arm motions. You're putting your arm or hand in a weird position on a daily basis. So it's got to be constant. It can't be, oh, I do this once a week or twice a day. It's got to be, this is all I do. So I'm using the drill press, or I'm using the metal polisher, or I'm constantly putting my hand in this weird position every day and putting these cables or doing something with your hand. So those are the fact patterns where carpal tunnel syndrome I could see develop. Cases where, and when I say that these are claims that I've dealt with and I've gone to hearings for, and the general pattern that I see. So harder cases, it's not impossible, but it's harder cases, or we've seen claimants where they've opened boxes or they're lifting boxes, and or they're lifting boxes and they're taking product out of a box and they're putting on shelves, or they're breaking down cardboard boxes. So why these are problematic is, you know, one, the general public lifts boxes, you know, maybe they don't lift to the degree that the injured worker are lifting, but the IC will say, hey, everybody lifts boxes, everybody lifts things. I lift things every day in and day out. So it's not anything different from what the general public is exposed to. You could, and the counter argument would be like, sure, everybody lifts boxes, but I'm lifting, you know, 200, 300, 400, 500 boxes a day, or I'm closing the lid on, you know, 900 lids, you know, per hour. So that would be a counter argument to that. But again, if between injuring, developing carpal tunnel syndrome using a machine like a drill or something versus lifting boxes, putting product on shelves, you're going to have a much easier situation with the first cases versus the second case. So with carpal tunnel syndrome, it is a condition that there will definitely be a file review, and there'll probably be either the BWC or the employer will probably have an independent medical exam. They'll examine you, they'll look at all your records, they'll delve into your history, you'll delve into what you do outside of work. They'll look for any holes to deny the carpal tunnel syndrome. The employer will also, if you work for, like, say, you know, an Amazon or FedEx or Cardinal Health or whatever, they're going to have pick information. They're going to have statistics upon how many boxes you pick in a day, the weight of those boxes, how many things you process. They'll have all the information about what you've done, and they'll use that to refute whatever assertions you claim in regards to the boxes or whatever you're doing. So that's another complicating factor. So they're definitely going to do an IME, an independent medical exam. They're definitely going to examine you, and then they're going to look in your, like I said, they're going to look in your history. They're going to see what you do. So do you play guitar? Do you drum? Do you sculpt? Do you do gardening? Do you lift? Basically anything that involves the use of your hands or arms, they're going to look at, and they're going to use that as, again, another thing as a basis of their argument to deny the carpal tunnel syndrome as an occupational disease. So if you sew, lift, sculpt, garden, anything using your, any hands or whatever, it's just a further complicating factor. So also they're going to look at your medical background. So, and this is what I went to before, but diabetic. Are you diabetic? So if you're diabetic people are predisposed to developing carpal tunnel syndrome. Is it bilateral? If it's bilateral, again, that goes towards this other thing that if it's a inherited disorder, it has a genetic basis, particularly if you have a family member, mom, dad, sister, brother that also have developed carpal tunnel syndrome. So if it's bilateral and a family member has it, that's kind of a double whammy. But if it's bilateral, that's because usually you'll develop it, like for instance, if you're using the drill, you're going to develop it on one hand. If it's bilateral, it kind of goes to the fact that it's probably not a result of your work activity. It's more a result of some predisposition in your own body that led to the development. Doesn't mean you can't get the claim allowed or the condition, but at the industrial commission level anyways, it's probably going to be, if I were to go in a hearing with that fact, if you had bilateral, I would have to see what other things are going on, but I would definitely veer towards more that's a weaker claim, and there's more of a reason that it's probably going to be denied. And then with every industrial commission hearing, a big factor is not only the underlying substance of the claim or condition or whatever you're trying to pursue, but it's also who is hearing the hearing. Is this hearing officer, have they developed carpal tunnel syndrome, which, if they've had the personal experience or they know somebody, they might be more inclined to allow the condition. Also, are they conservative or are they more work employee friendly? So, and there's definitely there's definitely hearing officers that lean one way or the other. And I mean, it would be nice if that wasn't the case, but there's bias, a ton of bias. And I could predict with reasonable accuracy how a claim is going to go, depending on who the hearing officer is hearing the issue. So sad fact, but that's the case. So what's going to happen is, if the claim gets denied, the occupational disease of carpal tunnel syndrome, the next step would be you're going to have to file in the court of common pleas. So in whatever area, wherever you're working, if you're working in Columbus, it'd be filed to Franklin County Court of Common Pleas. And then the next challenge would be, what is the basis of the diagnosis? Was it just the base, BWCPR, basically the occupational doctor, or was it a hand specialist? You'd be better suited if you had a hand specialist diagnosed that CTS, because then you could go and ask that same hand specialist to serve as your medical expert, because you're going to need a medical expert in all workers' compensation cases dealing with right to participate issues, i.e. you're trying to get a claim allowed or a condition allowed, unless it's something super duper simple, like a laceration or contusion. Anything else, you're essentially going to need a medical expert. And so the difficult situation with carpal tunnel cases is, like, hand doctors, in my experience, are not the cheapest medical experts. So, and if your base physician of record, the occupational doctor, had diagnosed the CTS, they would be cheaper than the hand specialist, but then they'd also be less credible, in relying upon their opinion as to how this developed. So it'd be better to have a hand specialist, because the hand specialist does surgery on these treatments. They see this condition all the time. They do surgery on it. They diagnose all the time. They would just come across more credible, more reliable, and that'd be better for your case. But they're not cheap. So in the pantheon of medical experts, you have your spine doctor, your shoulder doctors. They cost a certain amount of money, and then hand doctors and I just find that they're more expensive. They're definitely more expensive. They're not the most expensive experts. The most expensive experts are going to be the ones where you're getting more and more specific type of things, like a toxicologist is going to be expensive, but they're not cheap. It could be anywhere from $48K to hire them to serve as your medical expert. It might cost more. So that being said, carpal tunnel syndrome is a condition that you can pursue through the Ohio BWC. It presents its own challenges. Definitely, if this is something that's been diagnosed in your claim, if you don't have an attorney yet, definitely call an attorney and just get their opinion, see if they'll get involved. They may not wish to get involved because sometimes these kind of things are, um, sometimes these kind of claims, depending on how the carpal tunnel syndrome manifested, just not great claims. And they're not, and then what I mean great is they're going to be a denied condition, and then it's going to be very expensive. And unless you, the claimant, are willing to kick in money, i.e., for that medical expert, anywhere up to 8,000 for the medical expert, it's kind of, it's kind of hard to always justify that going forward. And a lot of times, sometimes you'll try to settle these, and the employers, they're not, for these type of claims, they're not always the highest value. So they're kind of expensive to take a trial. And then you, the claimant, if the idea is, hey, I want to try to settle this, a lot of times they're not going to offer great settlement amounts for these conditions. But definitely talk to workers' comp attorney, talk to many workers' comp attorneys, see what they have to say. Somebody may get involved, and basically that's going to kind of show you, it's kind of be an acid test whether it's worth pursuing through the workers' comp system or not. And then otherwise, even if you're going to pursue the carpal tunnel syndrome through the workers' comp system, depending on what the fact pattern is underlying the manifestation of the condition, it's probably going to go to trial. So if you have personal insurance, Medicaid, or some other VA benefits, if there's some way for you to get, if you need surgery to fix it, get the surgery through, undertake it through the personal insurance, or Medicaid or VA. Get it undertaken, because but by the time you get in the trial, you're going to have been walking around with this thing for a year and a half. And it's, if you can get it taken care of medically, you're in a much better position just as a human being and living with your life. And then you still have a claim. You'll still have this, you could still either settle or go forward with your lawsuit. It's just because you go to trial doesn't mean you have to still suffer from the condition. So you can still go to trial, and you can, even if you've medically fixed the carpal tunnel syndrome, you could still go to trial for that carpal tunnel syndrome. And then if the claim's allowed, if you want to pursue, try to get your deductible back from your personal insurance, you could try that. It's not always easy, but that's certainly an option as well. So that being said, if you have any questions, concerns, comments, you could always call, email me, or leave comments in this below. Otherwise, thanks for listening to this video, and I wish you good luck and Godspeed.